The case I'll be covering today is Doug C. versus Hawaii. A little background is that Doug C. is the father of Spencer, who was diagnosed with autism at age 2. Spencer was enrolled at Horizons Academy, a private education facility which was fully paid for by the Department of Education because Spencer was qualified under IDEA. In 2010, Doug was in communication with Spencer's IEP team about rescheduling their annual IEP meeting because he was unable to attend. The meeting was rescheduled twice, and the second time that Doug couldn't make it, instead of working with him to reschedule at his request, the team went ahead and had the meeting without Doug. The ethical dilemma is that Doug was not in attendance of this annual IEP meeting, which resulted in Spencer's relocation to a public high school in Maui, which was decided by the IEP team without parental consent because they hosted the meeting without Doug, and he was only notified after the fact. This means that Spencer will be leaving his private educational facility and going to a public school. The action taken is that after finding out about this, Doug immediately rejected the IEP. He ended up funding his son's private education at Horizon Academy without government support, so he was paying out of pocket. And he also filed a request for a due process hearing under IDEA, which was initially dismissed. The Ninth Circuit Court ended up picking up the case, going back on the court's decision, and the Court of Appeals reversed the court's judgment, and they based it on the agency was required to include the child's parents in the IEP creation process unless the parent affirmatively refuses to participate. So if Doug refused to attend or did not work to reschedule the meeting, then it would have been a different story. However, he was actively trying to participate in his son's meeting. The court found that the failure to include Doug in this meeting violated the procedural requirements of IDEA and therefore invalidating the IEP. The key takeaways that are linked with this IDEA principles in the category of the IEP rights require planning and participation of the parent. So obviously, Spencer's parent was not included in any of the planning or the discussion of the IEP because he was not in attendance. Procedural safeguards, which is what the court actually decided on the base of. I included a quote here. Parents have the right to review all educational records pertaining to their child, receive notice prior to meetings about their child's evaluation, placement, or identification, and to obtain an independent educational evaluation for consideration at such meetings, as well as parent participation. The placement decision, which is what Doug had no say in because they ended up changing his educational placement. Participation, which he was not there, so he could not participate. Notification, which he received after the fact. And then Doug also has the right to refuse what the team had suggested, which is what he did by denying and refusing the IEP that they made. A big quote that I think is important is parents are equal participants and decision makers in their child's educational experience.